I will hand over to Brian.
There we go. Good morning, everyone. So today, I have just 20 minutes to present a few ethics case studies. Now, for those of you that don't know, I've created a webinar series called Everyday Ethics. And the archive of these webinars is on the CAR website. At the end of this presentation, I'm going to show you the link to see those webinars. And so far in those webinars, I've gone in depth into almost every single article of the Code of Ethics. So far I've covered articles 1 through 16. And in each of these webinars, we talk about some key concepts to know about each article of the Code of Ethics. And then we cover usually about 8 case studies for each article. So each of those webinars is around an hour long. So total, I think there's about 10 hours of webinars if you want to delve even more deeply into the Code of Ethics. So today we're just going to skim the surface a little and talk about 3 articles of the Code of Ethics that I was asked to cover today. So first we're going to start off with Article 2. And Article 2 says that realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property or the transaction. And then the second part of Article 2 are the exceptions to that general rule we see in the first sentence. So it says realtors are not obligated to discover latent defects in the property. So sometimes there is confusion as to what do we mean by latent defects? What is latent? Latent is really just a synonym here for hidden. So a latent defect is some negative feature of the property that you wouldn't be able to discover by doing an ordinary visual inspection of the property. So you're not obligated to discover them. Of course, if someone actually tells you about a particular defect, then if you conceal that defect, you would be in violation of Article 2. There's just no obligation to discover it if you don't already know about it. Additionally, our Article 2 says that you're not obligated to advise on matters outside the scope of your real estate license. So that would be matters related to, for example, the practice of law, matters related to engineering, matters related to accounting, anything that wouldn't normally be covered by the practice of real estate under your license. You're not obligated to advise on those kinds of things. And then finally, you're not obligated to disclose facts which are confidential under the scope of agency or non-agency relationships. So one more key concept for Article 2 that I always like to talk about is that there is a due diligence standard. So a realtor who is accused of violating Article 2, the hearing panel must determine whether a realtor, a reasonably competent realtor in the same circumstances would have exaggerated, misrepresented, or concealed the relevant fact in the case. And if the panel decides that the reasonably competent realtor wouldn't have done that, then there is a violation of Article 2. However, if a reasonably competent realtor wouldn't have been able to avoid exaggerating or misrepresenting or concealing in a particular circumstance, then the panel should find that the realtor is not in violation of Article 2. So now we're going to cover the case study I have for Article 2. So in this case, buyer B is a retired college professor. And the buyer came to the office of Realtor A, who's a cooperating broker, in search of a large house that she wanted to occupy with a small apartment and use the remainder to operate a residential club for grad students. So Realtor A located a large old mansion listed with Realtor C, and it appealed to buyer B. And after visiting, the buyer said she was interested in the house if it could accommodate as many as 11 tenants. And by planning double occupancy of the large bedrooms, B found that she could accommodate 8 roomers, and in addition, there were 3 small rooms upstairs that had been used for storage. But Realtor B suggested that they might make acceptable single rooms. So buyer B agreed with that, and sale was made. However, and there's always a however because this is an ethics case, 2 months later, buyer B was advised by the building department that the 3 small rooms upstairs couldn't be used as dwelling rooms. since the windows were too small to meet code requirements, and she was advised it would cost $1,480 to replace the windows. So B proceeded to file an ethics complaint against Realtor A, and at the hearing, A testified that he had acted in good faith and had not deliberately failed to disclose any pertinent facts. And he also testified that he had urged the buyer to consult with an engineer and to check with the zoning authorities prior to making an offer. So now I'm going to ask all of you, do you think that Realtor A violated Article 2 here or no? No? So who says yes? Raise your hands. And who says no? All right, I'm thinking the majority here is no, and the majority is correct. So let's explain why that is. So one thing I didn't mention, these case studies come from NAR. NAR publishes a series of case interpretations which help to explain all of the articles of the Code of Ethics. So NAR considers these case interpretations to be persuasive authority. So that means if you ever get a case that's similar to one of these case interpretations, you can refer to the case interpretation as a hearing panel and say, because NAR said this should be the outcome, we're going to say this is the outcome in our case as well. So that's kind of the background of where these case studies come from. But NAR here says that Realtor A satisfied his duty to the buyer by recommending that the advice of experts be sought out and considered by the buyer prior to making an offer to purchase. So if you'll go back to the example here, Realtor A testifies at the hearing that he urged the buyer to consult with an engineer and to check the zoning authorities prior to making an offer. So that was important for the realtor to mention that. The realtor, of course, is not necessarily going to be an expert in whether these dwelling rooms meet the building codes or not. So this is a really good example of two of those exceptions to Article 2 that we discussed. Number one, it's a latent defect. It's a hidden feature of the property, a hidden negative feature, the fact that these rooms couldn't be used as dwelling units. And it's not something that the realtor would have been able to discover by performing a visual inspection of the property. It's also the fact that the rooms didn't meet the building codes, a matter that would be outside the general scope of the realtor's license here. So it's not a fact that the realtor really knew or should have known. So the fact that the realtor recommended that the advice of experts be sought meant that the realtor fulfilled his ethical duty here and wasn't in violation of Article 2. Yes?
But did he do it in writing?
So you're asking, did he do what in writing? Did he recommend that the advice of experts be sought in writing? That would certainly be advisable, but whether or not it was done in writing, we'll say that the hearing panel believed the testimony, that it was proven that the realtor had actually made that recommendation here. All right, so now I'm going to move on to the next article I'm going to cover, and it happens to be your Code of Ethics article of the day, Article 13. And Article 13 says that realtors shall not engage in activities that constitute the unauthorized practice of law, and shall recommend that legal counsel be obtained when the interest of any party to the transaction requires it. Now, one major key concept for Article 13 is that a violation requires a finding that the realtor undertook matters or gave advice regarding matters affecting the legal rights of a party that were beyond the ordinary practices in the real estate industry. So, for example, helping a client fill out a CAR standard form, I guess you could argue that in a way it's practicing law because you're helping fill out a contract, but that's not beyond the ordinary practices in the real estate industry, so that's obviously not going to violate Article 13. The second key point here is that a realtor must recommend legal counsel to any party to a transaction if a reasonable realtor in the same circumstances would have known that the interests of a party could be negatively affected by the lack of legal counsel. So again, we have a due diligence standard for that duty to recommend counsel. The panel will have to put themselves in the shoes of the realtor, and they'll say, would a reasonable realtor have recommended counsel in this circumstance? So let's cover our next case study related to Article 13. In this case, Realtor A was the listing broker for 25 acres of land owned by client B. And shortly after Realtor A's sign was placed on the property, customer C called Realtor A and expressed interest in purchasing the property. And after inspecting the property, C made a full price offer, and surprise, client B prepared a counteroffer at a higher price. Realtor A realized that he might have a legal claim for commission from client B, but not wishing to jeopardize their relationship, agreed that he would go back to customer C and attempt to negotiate a higher price. Upon being informed of the property owner's change of mind and his requested higher price for the property, C became upset and indicated his intent to consult his attorney to determine if he could force the seller to go through with the sales transaction at the price for which it had originally been offered. And at that point, A advised customer C that in his opinion, litigation would be lengthy and expensive, and that in the final analysis, the sale could not be enforced. And on the basis of A's advice, customer C agreed to the higher price, and the transaction was consummated. Shortly after that, customer C complained to the Association of Realtors that A had provided bad advice to him. So there was a disciplinary hearing, and at that hearing, customer C indicated that he had intended to consult his attorney. However, because of the persuasive personality of Realtor A, many realtors are quite persuasive, aren't they? And Realtor A's assurance that a legal action would be an exercise in futility, he had not consulted his attorney. Realtor A testified and advised the panel that he had told customer C he could consult his attorney, but that in his opinion it would be a waste of time. And he defended what he had told customer C, stating that it was only his opinion and not intended as a conclusive statement of law, and in fact it was a correct statement under the law of the state. So, do we feel that Realtor A violated Article 13 or no? Who says yes? And who says no? All right, there's a little bit of a split here. So, according to NAR, Realtor A has violated Article 13. Now, remember, there are two prongs to Article 13. There's the unauthorized practice of law prong, but then there's also the obligation to recommend legal counsel prong. And NAR says here that that first prong wasn't violated, but that second prong was. So let's explain why. The panel concluded that Realtor A, in pointing out the fact that legal action was likely to be time-consuming and expensive, was stating a practical circumstance which customer C should consider, and that was proper. So that was not an unauthorized practice of law. The panel further concluded that the expression of an opinion as to the probable outcome of the case was fine. That wasn't unauthorized practice of law. However, the panel also noted that a realtor is obligated to recommend counsel be obtained when the interest of any party to the transaction requires it. And here, A was definitely aware that the interests of customer C required a legal opinion as to whether customer C could compel the client B to convey title to the property. And he didn't intend his personal opinion to represent a statement of law, but Realtor A was obligated to affirmatively recommend that customer C consult his attorney to definitively establish the legal rights in question. And by dissuading him from consulting the attorney, that was a violation here of Article 13. It's an interesting one. That's why I picked this one for Article 13. I'm trying to pick the ones where there might be a difference of opinion, because that's more interesting, isn't it? All right, so now we're going to cover the last article I'm going to be talking about today, and that is Article 15. Article 15 is a duty that realtors have to other realtors. Now remember, the Code of Ethics is divided into three sections. We have duties to clients and customers, duties to the public, and duties to other realtors. The first article I talked about, Article 2, that's a duty to clients and customers. Article 13 is a duty to the public. And now finally, Article 15 is a duty that realtors have to other realtors. And that is a duty that realtors shall not knowingly or recklessly make false or misleading statements about other real estate professionals, their businesses, or their business practices. So in order to violate this article, there needs to be some proof of intent by the realtor that made the statement. So the speaker must know the statement is false or misleading, or if they don't know for sure that it's false, they have to be indifferent to the truth or falsity of the statement. In other words, they said it recklessly, not knowing whether or not it was true. So one of those two things has to be the case. A very important point here. True statements and opinions do not violate Article 15, even if they are negative. Why do we think that is? Now, The reason for that is there are certain laws, both federally and state laws, that prohibit anti-competitive conduct. And if we as a trade association prohibited competitors from saying negative things about their other competitors, that would be anti-competitive and it would violate antitrust law. So it's permissible to say a negative thing about your competitor, but it has to be true. You can't make something up. So in order to violate Article 15, the statement that the realtor makes must be about a competitor, it must be about their businesses or business practices. And purely personal, non-business related attacks are not going to be covered by Article 15. So it only covers anything negative you would say that is untrue about a realtor related to their actual real estate business and their business practices. A couple of other key concepts, and these are mentioned in the standards of practice for Article 15. First of all, the obligation to refrain from making false or misleading statements about other real estate professionals and their businesses includes the duty to not knowingly or recklessly publish, repeat, retransmit, or republish false or misleading statements that are made by others. So let's say you have a website or a social media site that invites comments, and you see that someone has published a comment about another realtor that you know is untrue. Once you've realized that that comment is untrue or false or misleading, you would have the obligation to remove that. Otherwise, you're retransmitting that statement, and you could be in violation of Article 15. Next point here. The obligation to refrain from making false or misleading statements about a realtor's businesses and business practices includes the duty to publish a clarification or remove statements made by others in electronic media. So that also covers what I was just talking about. So you don't want to repeat any false or misleading statements made by others, and you need to remove and publish a clarification if people publish false or misleading statements on your own websites or electronic media. All right, so now let's move on to our last case study of the day. In this case, following a round of golf early one morning, homeowner A approached Realtor X, and the homeowner said, "We've outgrown our home, and I want to list it with you." "I'm sorry," said Realtor X, "but I represent buyers exclusively." "Then how about Realtor Z?" asked homeowner A. "I've heard some good things about him." "Well, I don't know if I would do that," said Realtor X. "Well, he does represent sellers, he doesn't cooperate with buyer brokers, and as a result, sellers don't get adequate market exposure for their properties." So later that day, someone said, "True. Do you know Realtor Z?" Later that day, homeowner A repeated Realtor X's remarks to his wife, who happened to be a close friend of Realtor Z's wife. So, of course, within hours, Realtor Z had been made aware of Realtor X's remarks that he had made to homeowner A. And Realtor Z filed a complaint against Realtor X, charging him with making false and misleading statements in violation of Article 15. At the hearing, Z stated, "I have no idea what Realtor X was thinking about when he made his comments to homeowner A. I always cooperated with other realtors." Realtor X replied in response, "Well, that's not so. Last year you had a listing in the MLS, and when I called to make an appointment to show the property to the buyer, you refused to agree to pay me." Realtor Z responded that he had made a formal offer of subagency through the MLS with respect to that property, but had chosen not to offer compensation to buyer agents through the MLS. And he noted that the fact that he had not made a blanket offer of compensation to buyer agents should not be construed as a refusal to cooperate, and that he had in fact cooperated with Realtor X in the sale of that very property. In response to Realtor Z's questions, Realtor X did acknowledge that he had shown his buyer client Realtor Z's listing and that the buyer had purchased the property. Moreover, Realtor X said upon questioning by the panel members, he had no personal knowledge of any instance in which Realtor Z had refused to cooperate with any other broker, but had simply assumed that Realtor Z's refusal to pay the compensation Realtor X had asked for was representative of a general practice on Realtor Z's part. All right, so based on all of this testimony, do we feel that Realtor X violated Article 15 or no? Who says yes? Who says no? All right, there's a divide here, and many of you didn't vote. I think you're afraid of getting this one wrong. There's no penalty for getting it wrong. According to NAR, Realtor X violated Article 15 here. That's because cooperation and compensation are not synonymous. So though formal blanket offers of cooperation and compensation can be communicated through MLSs, even when they're not, cooperation remains the norm expected of realtors. But to characterize Realtor Z's refusal here to pay requested compensation as refusal to cooperate, and then to make the assumption and subsequent statement that Realtor Z generally did not cooperate with buyer agents, that was false. Realtor X had nothing really to base that statement on. That was going beyond the truth of the matter and beyond Realtor X's knowledge. So it was a very reckless statement to make. And Realtor X made it without caring whether or not it was true. So for that reason, NAR says that this is a false or misleading statement about a competitor that would be in violation of Article 15. All right, so that's all I have for you today. If you're looking for any other pro standards resources, I have a couple of links for you here if you want to take a picture of those. And then on my next slide, once you've done that, I'm going to show you the link to see the Everyday Ethics webinars. If you want to know everything you could possibly want to know about the Code of Ethics, I highly recommend these webinars. As I said, right now I've covered Articles 1 through 16, and in October I'm going to finish off the series and cover Article 17. So we'll have the complete set of webinars available and archived on the CAR website, viewable by you at any time. So here is the link for that. It's under the Legal tab, under Legal Webinars, and then Ethics. I'll go back to the other slide in a second. Just taking a look to see if everyone's got that. One more minute for this slide. All right, thank you, everyone. I will be at the meetings in Long Beach, so I'll be there the whole time. If you see me, come up and say hi.